Can lawyers be sued for negligence in the future if they fail to use tools like TimeBinder or similar immutable verification systems, in a world where AI-powered fraud is becoming common? This question is increasingly relevant for legal professionals globally. The issue is not sensationalism. It's about understanding how rapidly the risk profile around digital evidence is changing, and how this may influence the standard of care expected of lawyers. AI can now fabricate documents, alter PDFs, rewrite metadata, and generate convincing versions of files that appear older than they really are. When authenticity is challenged and a lawyer cannot objectively prove when a file existed, the risk does not sit only with the client. It may fall directly on the practitioner. Negligence in professional practice often hinges on one test: whether the lawyer acted with the level of care a reasonably competent practitioner would have exercised at that point in time. As evidence manipulation becomes easier, courts and insurers may expect lawyers to adopt stronger, verifiable measures to protect their clients' documents. Immutable timestamping is one of those measures. Tools like TimeBinder make it possible to prove with cryptographic certainty when a document, photo, recording, or draft existed. The file is hashed locally in the browser, and a tamper-proof record is anchored to the Bitcoin blockchain. The result is a permanent, verifiable audit trail that cannot be altered or backdated. The key question becomes, if this technology exists, is simple to use, affordable, and specifically designed to prevent authenticity disputes, could a lawyer be criticized for not using it? Consider a common scenario. Two versions of a contract appear. One supports your client, the other supports the opposing party. If you cannot prove when your version existed and the opponent produces a seemingly clean metadata trail, your client could lose the dispute entirely. In that situation, an insurer or court may ask why no independent proof of time was obtained. This risk is global. Courts in every jurisdiction are now grappling with how to trust digital evidence at scale. The expectation that lawyers will anticipate fraud risks is not new. What is new is the speed and sophistication of AI manipulation and the availability of simple tools that neutralize it. Think about the documents your practice relies on every day: draft agreements, client instructions, settlement calculations, due diligence bundles, internal file notes, affidavits, screenshots, and emails with attachments. Any of these could become the subject of a dispute in the future. If you do not have independent proof, the authenticity of the entire matter can be questioned. TimeBinder offers a practical way to reduce this risk. Files are hashed locally, nothing is uploaded, and each timestamp produces a verifiable certificate backed by the world's most secure blockchain. It gives lawyers a way to lock their documents to time, creating an indisputable record that can be produced years later. So can a lawyer be sued for negligence for failing to use tools like this? Today, the answer depends on jurisdiction, context, and professional guidelines. But the direction of travel is clear. As document manipulation becomes more common, the standard of care will evolve. Failing to adopt readily available protections may increasingly be viewed as a professional oversight. The safest approach is to begin integrating immutable timestamping into your workflows now. Make it part of your drafting process, your evidence management, and your client protection strategy. In the age of AI-enabled fraud, authenticity must be verifiable, not assumed. To learn more, visit timebinder.io.